And now I will introduce today's speakers. Heather Bukta has a transactional practice covering the areas of e-commerce, software, technology, and data privacy, with an additional focus on copyright and trademark prosecution. Her work focuses on software agreements, IT outsourcing, internet terms and conditions, privacy policies, electronic contracting, technology development agreements, copyright licenses, copyright prosecution, trademark licenses, and trademark prosecution. Heather is a certified information privacy professional through the International Association of Privacy Professionals. Rowan Smith practices nationally in several areas of technology and intellectual property law, including patent prosecution, copyright and trademark registration, licensing, and technology-related transactions. Rowan has drafted and prosecuted patent applications in many technology areas, including in the field of semiconductors. He also has considerable experience in IT, having drafted and prosecuted patent applications relating to e-commerce systems, data security technologies, and various network communication systems. And now I will turn it over to Heather and Rowan.
Great. Well, thank you all for being here today. I have the pleasure of getting us started. So the title of our presentation is something that is actually a fairly common question, or similar to the common questions that we get in the IP space. And so what we hope to accomplish with our time together today is to really help differentiate for you the four primary types of intellectual property, allowing you to hopefully serve as a more efficient resource for some of your internal teams, along with providing you some tips and tools to figure out how some of these intellectual property types can fit within your business. If nothing else, giving you some tools to hopefully issue spot and figure out what questions you may need to be asking and how you can go about it. And finally, the goal is to give you some early steps that you can take to help maximize your ability to exploit your intellectual property, of course, then adding value to the business and generating more revenues and profits, which is always everyone's goal. So with that, and hopefully by the, oh, I did something. Hopefully by the time we, oh, there we go. It is helpful to have technology folks doing the technology presentation, although I just apparently failed. So the ultimate question for today's presentation, can I patent my copyright with a trademark? And the answer is no. Each of these types of intellectual property are, in fact, different concepts, carrying different rights, different remedies, and serving different purposes, quite frankly, within the realm of the industry and business in general. There are, of course, intersections, which is what typically leads to some of the confusion among the various types of intellectual property that are out there. So with that, we thought to help us through our brief journey today, where we are trying to squeeze probably 3 hours of information into an hour, if not more. Yeah. We thought we'd introduce this with a case study. So let's take the example that you've been given a new job assignment. Your company is launching the new hottest widget, which we have cleverly named the Uber spinning gizmo. Everyone at the company is concerned about getting to market, who's going to steal it, we have to get to market first, and the company has looked to you to say, what can we be doing to ensure that we are going to have a place in the market, that we're going to have a niche in the industry, and nobody else is going to be able to step on our toes to infringe on what we're trying to do from a business perspective. So looking at some of the things about, what is at risk, and when we're talking about intellectual property, what should you be looking at, who should you be talking to, and what kind of questions can you be examining to figure out what options you have to help protect your company's Uber spinning gizmo. So with that, I am going to turn it over to Rowan to get us started with some of the who, what, when, where, and why.
Yeah, so I think the first step in protecting the IP around this incredibly fantastic new super duper product is really you've got to understand what IP is within the company that you need to protect. I think it's very often the case that we presume the only valuable material is going to be coming out of the technology geeks in the product development department, but you need to keep in mind that there are organizations throughout the company that are generating valuable information. It's taking a lot of money to research and develop this material, whether it's technology data, marketing plans, sales efforts, plans to move into particular marketplaces, things like that. Everybody is working on developing valuable information, and we need to think about, will the information being generated fit into one of these buckets that Heather talked about to potentially be protected? I think a good starting place is to look at what have we developed that's secret? What is confidential within the organization that the teams are working on, and what steps can we take in order to protect that information? And that all starts with the notion of trade secrets. I feel like trade secrets are really the default state for IP when it's first created. I think it will, whatever form of the information, I think it first fits into this category of trade secrets. The reason for that is trade secret protection can apply to a very broad scope of information. Obviously, there are kind of the stereotypical things that can be trade secrets. They can be formulas and source code for software applications and things like that, but it can be much broader than that. The information that we're developing that we may be able to protect can be much broader. It can be things like marketing plans. It can be market research. It can be sales, obviously sales numbers and customer lists. It can be negative information. So it can be data that describes potentially failed efforts, that where we've spent some money, we've discovered that a particular avenue is perhaps not a very profitable one. And it's one that if competitors learned that information, they would be able to avoid that same cost. So this negative information can also be potentially the subject of trade secret protection. Now, in order to actually attach protection, it's not just enough that this information exists. This valuable information. It's not merely its existence that makes it a trade secret. We have to take some action around that information in order to have it spring into existence as a trade secret. And that key thing is this bullet point 2 that we've listed here, which is presuming that the information is secret to begin with, you have to implement reasonable efforts in order to maintain this information as a secret. Once you have done both those things, so once we've got some information that's a valuable secret, and we have taken those steps, those reasonable efforts in order to protect the information, that's when we now have established a trade secret, and now it's something that may be protectable. And there is no registration process for a trade secret. There is no application process. It's merely doing those 2 things around a trade secret that make it spring into existence. So let's talk a bit about what these reasonable efforts look like. In large part, it's going to be kind of what's standard for the industry. Step 1 is we've got to work with our teams. We've got to understand what is the information that they're generating. Who are the people generating the information? Who have access to it? Where is the information stored? We need to look at the way this information is managed, and then we can start to think about, okay, what are these reasonable efforts that we need to put in place in order to protect this information? And it may be very different for different departments. For the product development folks, if they're working on software, there's a lot of technology tools that we can use to implement protections for their trade secrets, their source code. For example, there's content management systems where we can restrict access to the source code to particular individuals. I would think, though, about potentially using tools like that on the software side or other kind of content management systems to put in even more rigorous protections. If we have a very large software project that we're implementing with very many modules, it is usually not the case that every single developer on the team needs access to every single piece of source code. Usually teams will be working on individual modules, and if that's the case, I think a reasonable effort may say only the teams working on a particular module should have access to the source code for that module. And then to the extent different teams need access to the functionality of other modules, they share compiled code. That's a software example, but I think similar principles would be applicable to other management systems, maybe where we're managing test results from a laboratory that we're running, or systems that store technical drawings and CAD files and things like that. For the kind of marketing and other product development team members, they may have a lot of mock-ups and samples that they're putting together. Again, it's the case that not everybody in the company needs access to those samples. The accounting intern does not need to be walking through the engineering facilities and posting pictures of what we're working on up to Facebook or whatever social media platform they like to use. So for things like that, again, it's only the people that are working on those samples or the mock-ups that need access to them, and we should implement procedures to limit that access accordingly. In terms of written materials, that is a very big area where we need to be very careful to make sure that we're making reasonable efforts to protect the confidentiality of those materials. Step one is to make sure that things we have identified in our audit as sensitive information is being marked as such. We should mark things as confidential. We may want to consider implementing password security, particularly if these documents are being forwarded via email. Password protection can protect against that inadvertent forward to where an email is forwarded to somebody it shouldn't have been. At least if the files are password protected, we may still get some security there. The other thing I would try to discover as part of this audit and talking with your teams is identify if there's any exceedingly sensitive, mission-critical type information that these different groups are developing, and consider whether for a particular, for that category of information, we want to implement elevated efforts to maintain secrecy. That can be locked door requirements on offices where this information may be printed out or otherwise accessible, and then clean whiteboard, clean desk policies, again, just to make sure that that very sensitive information is being treated with an appropriate level of effort to protect the information. The more delicate the information, the more elevated those reasonable efforts become. Another big area we really need to manage is in terms of contracts with or working with third parties. You know, it's often the case that as in-house counsel, we may only learn that somebody on our team has been speaking with a third-party product developer or consultant when we get the contract saying, hey, we'd like to use their services, can you mark up the contract, and then we can go ahead and work with them. The problem is, in order to get to that point, there's already been discussion. You've already shared enough information in order to evaluate, you know, is this a good potential relationship? Will we work well together? By that point, you may have lost trade secrets, sensitive information may have been disclosed, and that any discussions like that should have been covered with some form of non-disclosure agreement. This happens all the time. People are under crushing budgets. They need to work with third parties. They will have previous relationships with people at other companies. It's just a natural thing for people to reach out and try and make those connections. But as part of this launch, I think what we'll be asking everybody to do is start thinking about what would be the procedures that we would put in place to govern the process of reaching out and working with those contractors, it should absolutely include prerequisites for having a non-disclosure signed and appropriate steps to manage the release of sensitive information. We do note that to the extent we're putting these policies together, all of this should be documented. It is absolutely not enough to say, well, obviously this was top secret because we all knew it was very sensitive. That's not going to work. You have to have these procedures documented. Your employee handbooks and guidelines should have statements about confidentiality and the obligations on people to maintain trade secrets. In terms of how you manage specific information, so I mentioned that the software team that has the repository where access is limited to certain developers or things like that, you should document those restrictions. We should know who has access to what. And then absolutely, as I just mentioned, in terms of working with third parties, you have to have a procedure documented for what the process looks like for working out, reaching out and making contact with a third party to talk about entering into a potential relationship. In all of this, personnel are key. Governing your employees, like I mentioned, through employee handbooks and guidelines, that's key. Two areas that are particularly sensitive and delicate around trade secrets are the cases of incoming and outgoing employees. Obviously, for an incoming employee, we're hiring someone because they've got great experience, they've worked in the industry, and part of that background will necessarily involve the learning of trade secrets of previous employers. We're hiring them for the general knowledge that they've developed in the field. We don't want those trade secrets that they've learned in previous jobs, because that then constitutes us misappropriating another entity's trade secrets. So again, part of these procedures and policies we need to put in place is the procedures to govern incoming employees. This should generally involve reminding the incoming employee about their obligations for maintaining the confidentiality of trade secrets of previous employers. We should document that we do that. And then also include a documented instance where we make clear to those employees we don't want those trade secrets. If you know trade secrets belonging to other companies, we don't want them. And I think those steps should be documented. The other kind of red flag situation is an outgoing employee. Obviously, this is an opportunity where we might potentially lose some of the trade secrets that this employee has learned while working for us. And again, similar to the incoming case, the outgoing case should also include a meeting with the outgoing employee to remind them of their confidentiality obligations, and also make steps to retrieve any and all assets that that employee has gathered while they've been working for us. So obviously that's laptops and memory sticks and you know, any documentation that they may have collected as part of working for us. Again, these should all be documented procedures. I have a bit of a legal slide here. So where do these rights actually come from? There is a Uniform Trade Secrets Act. The vast majority of states have signed onto it. It sets out the standards for what can constitute a trade secret and then what is misappropriation, which is in line with the materials that I've provided. Even though all the states had signed on to the same UTSA, there over time evolved some differences in the ways that the states applied the rules. And so fairly recently, federal law was passed, the Defend Trade Secrets Act. It basically reinstantiates the language of the Uniform Trade Secrets Act, but the goal is it will hopefully unify some of the different states' rulings into a single federal system. Also provides some other causes of action that have been noted in the slide. So I think we've talked about how to establish a trade secret. It's not just that the information exists, it's that we took reasonable steps to protect it, and we've talked about what those reasonable steps might be. So then the question is, well, is this the best form of protection for our IP? I mean, it sounds great. It's free. All we have to do is put some reasonable efforts in place, and they're reasonable. So that's probably a good thing. It's good that we manage our secrets anyway. So surely trade secret protection is the best, and we can go home now. But there are some restrictions, and these are so trade secret protection will protect against other people misappropriating your trade secrets. But there are some exceptions. Misappropriation doesn't include every potential way that a competitor could learn this information. Reverse engineering is not misappropriation. If we're selling a product, we've embodied some technology into that product, and a competitor can buy it off the shelf, break it open, look at the insides, and understand our technology, trade secret protection will not help us there. Similarly, independent invention is not misappropriation. So perhaps we sell a product, it embodies a very cool new technology. To the extent other people might be inspired by that to figure out how that technology operates, trade secrets won't provide any protection at all. So then we start to think, all right, well, we've gone out, we've done the audit, this is kind of the valuable information that we've talked about. Well, do we have some concerns? Could it be that some of this information could be reverse engineered? Could it be that perhaps it's difficult to protect? The information is going to leak out one way or another. If that's the case, we need to start thinking about alternative forms of protection. And this is where I think we start to say, okay, we've got this valuable information. Let's look at it and start to think, have we done some inventing? Have we developed a new technology? Because this is where we start to think about patents as being an alternative form of protection. Again, I think as part of this process, you'll go and talk to your teams. We've given you some questions here that I think will help you kind of tease out whether the information that the teams have prepared actually constitutes inventions. It's the types of things where, you know, if we've made a technological development and we know that other people are working on similar technology, or we've made a development and we know it's going to disrupt a particular field, if we're in those types of circumstances, then I think that gives you a good hint that, all right, we need to start thinking about potential patent protection. All right, so let's talk about patents, which are the second form of IP that we might use to try and protect this gizmo that we've been working on. So what is a patent? A patent is it's a property right. It's an exclusive right that says, once awarded on your technology, it says other people cannot practice that same technology. Prevents other companies from making, using, selling, offering for sale, or importing your invention. Patents are not necessarily a guarantee that you can practice your invention. It may be that there are other companies out there with patents on similar technology too, and you cannot infringe on those patents. And also patents cannot be awarded on everything. The Patent Office really wants to see a technological innovation before awarding a patent. So we mentioned that you might have trade secrets coming out of your marketing department. If those trade secrets relate to, say, new marketing materials, probably not patentable. It's not really a technological improvement. If your marketing department is working on new technology to analyze social media and buying habits in order to improve and provide new ways of communicating with potential customers, that sounds more like a technological innovation, and that might fall within the scope of patents. So what are the requirements in order to be awarded a patent? Our first major requirement is that the thing we're trying to protect has to be appropriate subject matter, and that's what I talked about. It's got to be a technological improvement. So we would basically take a look at the trade secrets that we identified earlier, identify potential areas where we might be subject to reverse engineering, or there might be risks like that. And if the trade secrets have a fairly technological bent, they may very well be something that we can try and protect via a patent. Second requirement is that the thing we are trying to patent must have utility. That's a very easy standard to meet. It has to be useful. And then the last requirement, and this is the one we usually struggle with, we have to demonstrate that our invention, our technology is non-obvious. This is the statement that based on everything that's been done in the past, is our invention sufficiently innovative as to be non-obvious. There's a note there that hints at the fact that these can be difficult standards to meet other than the utility one. They can be complex to apply and understand, and that's something obviously that your IP attorneys can help with. So we're going to go and talk to our teams. They are going to tell us that they are working on incredible, earth-shaking technologies. We're going to have hundreds of potential things to file patents on. Everybody's working on brand new technology. As new employees at the company, you're probably going to be overwhelmed by the number of innovations that you hear about. But what we want you to think about is tempering that feedback. I would say it's not enough that somebody has developed a really, really cool technical innovation. That by itself is not a good enough reason to file a patent application. It has to be a strategic innovation. So if you go and talk to the team that's working on the spinner gadget, and they're telling you, well, you know, we had this problem in our manufacturing lab with the way that the machinery was set up, and we had to come up with this amazing technology to make it work. Well, that sounds really cool. It's certainly the type of thing we might file a patent application on, but that's not strategic. It's peculiar to us. It's a technology that was developed only because of the way our manufacturing facility was set up. Competitors aren't going to copy us. That was a unique circumstance for us. If, though, the technology is something that relates to the general process for making the device, it's generally applicable, competitors will want to use it too, then that's certainly something we could file a patent application on. It's more strategic. It's going to give us an advantage over our competitors. So we've given you some hints here about how to kind of temper the feedback that you're getting from your engineers. If the improvement that we've made is a tweak to an algorithm on a back-end computer server, that if a competitor made the same tweak, we'd never be able to detect because it is hidden on a back-end server. It would be very difficult to detect. That also might not be the type of thing that we want to file a patent application on, because if we get the patent, how will we ever know to assert it? A quick note here, in terms of working through these decisions and meeting with your teams to identify potential things to file patent applications on, you want to move quickly. The US has changed to what's called a first-to-file system. That means the first person to file the patent application wins. If you and your competitors are working on similar technologies and they are trying to draft their patent applications as quick as possible, you need to do the same because you want to beat them to the patent office. The other timing issue, and the rules around this are fairly complicated. As this is a high-level presentation, I just wanted to make the general statement that once a disclosure has been made, so if you've had an engineer put a blog post up about the technology he or she is working on, you've started a timer. Once that public disclosure has been made, you've only got 12 months in which to get your patent application filed. That time goes very quickly. So the general rule, I think, is to move quickly. So if we have met with the teams, we've identified some strategic information technologies that warrant patent filings. What's the process that you're going to go through? Again, a very quick overview here. You want to meet with the inventors. You want to gather as much information as possible. Oftentimes, these inventions take place in fairly chaotic environments. Information will be dispersed. The engineers, the developers, they're busy. They don't really have the time to put together a very nice presentation for you. So it's really on us to work with the engineers and the developers in order to collect materials that describe this innovation. The more material you can collect, the more documentation, the easier it is then to work with your attorneys to prepare patent applications and get those on file with the patent office. A very short note on the process for filing and prosecuting a patent application. So once you have taken the materials describing this invention and it's been put into the form of a patent application, which is a document describing the technology, that application then gets filed with the patent office and you're now patent pending. That patent application now enters a period of examination where a patent examiner at the patent office makes sure we meet those three requirements we mentioned earlier: the subject matter requirement, utility, and obviousness. If the examiner thinks we haven't met those requirements, they will issue a rejection, and then we enter into a negotiation with the patent office over what protections should be allowed. Eventually, the examiner will agree that we've met the burden of those three requirements, and the patent will issue. This process, as we'll mention later, can take quite a while. This next slide, I just want to make a quick note about ownership. In the US, patents, unless there is some agreement to the contrary, patents are owned by the inventors. That means if your employees are developing new technology, if they're making inventions, without something to the contrary, they own them. You don't. The company doesn't. The way to mitigate that is we've got to put agreements in place, usually through the form of an employment agreement or language in an employee handbook, that confirms that any inventions developed by our employees will be assigned to the company. So this is obviously something that we want to document and make sure that we get in place to ensure that we own all the inventions around our spinner gadget. So are patents the best form of protection? Well, I'm a patent attorney, so yes, of course they are. They're awesome. But there are some exceptions that we need to think about. As I mentioned earlier, it can take a long time to get a patent, 2 to 3 years. If you're selling a product that only has a time in the market of a few months, filing a patent application might not be the most effective way of protecting it. Similarly, patents have a lifetime. They only last 20 years from the date that the application is filed. If you've invented a new soda beverage and hope it has a market lifetime of 200 years, perhaps protecting that beverage's formula via a patent might not be the best approach. A couple of things to think about there. Patents, some side notes, patents have the characteristics of being property. They can be transferred, sold, licensed as such. This can be very beneficial. I've seen for startups where you're trying to take on funding, having patent applications filed, it shows a nice asset that can be tied to that funding event. Also, obviously, facilitate the process of any kind of an exit plan associated with an entity like that. Patents as well, another thing to think about in terms of whether they're the best protection. They only protect the technology, the underlying technology that drives the product. It may be that the technology, particularly for a gadget like we're talking about, might not be the key element of the product. It might be other things like the product's appearance and the way it looks on the product shelf. So I think we then transition into another form of IP that we might consider in trying to protect this product. I think a couple of facts that we can add to this, the hypothetical we've been talking about that relate to this, to copyrights, which is the third form of protection. We're going to market in 6 months. It's not 2 years. This is going to be a very quick to market product. In this case, we are working on some very cool technology in the company, but we think there are competitors out there that might be able to make a product that offers some similar functionality using different driving technologies. I will turn to Heather for the copyright.
Perfect, thank you. So the thing to keep in mind when we look at this, when we look at the possibility that somebody else could have a similar product, such that they could work around the technology that's disclosed in your patent, they could do a couple of other things to still come to market with a product. Well, if a patent isn't going to do it, then what else can we look to? So that we turn to copyrights. Copyrights are distinct from patents in that the copyright is going to protect the particular expression of perhaps the underlying invention idea that may be disclosed in your patent. So it's not the concept, it's not the invention, it's your particular version of it. So the best way I've thought to describe it over the years is to say, the idea of a novel about a Southern belle during the Civil War, you can't protect that idea. Gone with the Wind, on the other hand, does have copyrightable expression. So it's the tangible results of that concept of your Uber spinning gizmo. So it's the particular artwork that your artists have come up with. It's the particular design format. Any software code that's in it, software code is a work of authorship. And can be protected as such. It's your user manuals, it's your specifications, your blueprints, any of the actual tangible materials that you have with respect to your product is what we can look to for copyright. There are some limits to copyrights. You do have to have some originality. It's a fairly low bar for what the Copyright Office considers original, and it does have to be fixed in a tangible medium of expression. So that doesn't have to necessarily, it gets to be a little bit of a complex conversation in this day and age when we talk about something being fixed in tangible form, because everything's on a computer existing in a cloud somewhere. But that still counts. If you have a file that has data in it, that has the draft of the next great American novel, that is sufficiently fixed in the tangible medium. It just has to be something that can be perceived, reproduced, communicated to somebody else in order to be copyrightable. What the copyrights do, copyright in a work of authorship grants the copyright holder a set of rights. The right to copy, modify, distribute, depending on the type of work, also the right to display and perform. So that is generally the list of exclusive rights that vest in the copyright holder when those copyrights are created. How do I get them? You actually don't have to do a thing. Copyright, similar to the trade secret we were talking about earlier, vest immediately upon creation. When you put pen to paper and start writing something down, you have, to the extent it's original, and you're not just copying something from someone, you have copyrights that attach immediately upon creation of that of that work of authorship. Now, in turning to some of the ownership issues that Rowan had mentioned, the question is, who do they attach to? And copyrights will attach to the original author, to the person who originally created that work. There are exceptions to that. If, unlike patents with copyrights, if it is an employee that is acting within the scope of their employment, then those copyrights do automatically vest in the employer. There is an incredibly broad and complex body of case law about when is something within the scope of someone's employment or not. The other term that you may hear from time to time is a work made for hire. My personal opinion is that there is potentially a bit of debate about what actually a work made for hire is. You will always see the agreements with independent contractors specifically say that something is a work made for hire, and that is the standard under the copyright statute, that, again, copyrights vesting with the author unless you have a written agreement with a contractor that specifically designates something as a work made for hire. However, if you dig into the statute a little bit, technically the definition is a little bit narrower than that. You have to have, obviously, the written agreement that specifies something as a work made for hire, but it also goes on to delineate a limited number of types of works. And so for that reason, oftentimes the agreements you'll see with independent contractors will have both a designation of the work as a work made for hire, and will have an assignment that says, in addition, the author assigns all rights, title, and interest to the hiring party. So something to keep in mind as you're engaging folks to work on your Uber spinning gizmo. Any of the artists that are developing the artwork, developing the packaging, all of those kinds of things, having the contracts in place. If they are with outside third parties, to make sure you get the requisite rights. And if you're having an internal set of employees work on that component of your product, making sure that it is the people designated within your company for that type of activity, and you're not bringing in the accountants to, not that you would bring in the accountants to work on marketing materials, but something to keep in mind. So in terms of, again, in terms of getting copyrights, making sure you have the sufficient contracts in place with third parties and developers to make sure all of that property vests in the original employer, the contracting party, the company. As Rowan mentioned, it's also helpful to address copyrights within your company IP policy, just making sure everything is covered in that. You will often see copyright notices. Copyright notices are legally not required, but they are certainly helpful. And I typically suggest that if you have materials that you're working on with respect to a product, put the copyright notice on there, the Circle C, the year it's developed, and the name of the company. If nothing else, that serves as a deterrent for folks that may get copies of that stuff at some point in time, to know that you do consider it your copyrighted material and will protect it and pursue it as such. As I mentioned, you don't actually have to register anything. Those copyrights vest immediately when you create a work of authorship, but you can register them. The United States Copyright Office works in tandem with the Library of, or is part of the Library of Congress, and does have a registration process. And it can have its advantages to go through that registration process. In fact, if you have to enforce any of your copyrights for copyright infringement, it is typically a prerequisite that you have that copyright registration. It's essentially, the judge is going to want to see, the court's going to want to see that jurisdictional requirement that there is in fact a copyright before they'll take the case. In addition, if you register your copyright within 3 months of publication, there are additional remedies that may be available to you, additional damages that you could pursue that you may not have been otherwise able to pursue in an infringement action. So not necessary to get a registration, helpful to do so, and helpful to do so earlier. I will say that, you know, if you make a decision not to file a copyright registration within the 3 month deadline, you certainly can do so later. it is, and you can do so on an expedited basis. If you find out that somebody is infringing one of your works, you can absolutely run to the Copyright Office and say, here's my work, I need to register it right now because I need to file a lawsuit. The filing fees for those copyrights on just a regular basis, they are less than $100, I believe, the last time I checked. If you have to file on an expedited basis, it's 7 times that. So the costs of filing on an expedited basis go way up. So again, something to keep in mind as you're looking at the assets that go along with your Uber spinning gizmo. So then, copyrights are generally free. They vest immediately. Are they the best thing I should be looking at for my product? They last a lot longer than patents do. Copyrights last for the life of the author plus 70 years, unless it is a work made for hire with an employee or an independent contractor under actual contract. Those last for 95 years from the date of first publication, or 120 years from the date of creation, whichever expires first. It's a long time for any product, typically within today's market. There are, of course, disadvantages. Again, it doesn't protect the underlying concept, does not prevent somebody else from coming to market with something similar. It just prevents them from coming to market with something that looks like your version of it or is copied from your version of it. It also won't prevent someone from selling a competing product under a similar name. Maybe they didn't copy your design. Maybe they worked around your technology, but they could still call it something similar within the market, theoretically. So what else is there that's out there? How do I make sure that I can differentiate my Uber spinning gizmo within the market? So that brings us then to the last of the 4 primary intellectual property types. And before I go too far down this path, the interesting thing about the distinction between trademarks and some of the things we've been talking about in terms of patents and copyrights. Patents and copyrights are actually, it's obviously a matter of federal statute. I believe the underlying purpose of patent and copyright was to allow inventors and authors to freely disseminate the great works that they were creating to better all of humanity, and still protect them individually. So that is really the underlying purpose of both patents and copyrights, is to allow for this free flow of ideas in society. Trademarks, on the other hand, have a very different purpose. They're also a matter of federal statute. There are also typically state statutes that provide for trademark protection. But the purpose of these statutes in the trademark context, it has nothing to do with the lofty goals of bettering society. It's all about consumer protection, to identify the source of a product or a service for a customer, so that I, as a customer, when I walk into a restaurant that has golden arches on it, I know what I'm going to get. I know approximately what it's going to cost. I know the quality of what I'm going to get. And I know approximately how it's going to taste, because I know what that brand stands for. I know the source of it, and as a consumer, when I go in to pay my money, I know what I'm getting for that. So trademark law creates assets for a company, and obviously trademarks can be some of the most valuable assets a company has. Sorry, Rowan. But that's not the purpose. The purpose is actually consumer protection. Some of the typical questions I get, I have a brand, how do I trademark it? Or I have a logo, I need a trademark for it. Those are theoretically all the same thing, and those terms can be pretty much interchangeable. The difference between a trademark and a trademark is really just the thing. It is the word or the logo or the tagline, the trade dress, the sound, the smell, whatever it is that actually serves as your source identifier. Your brand is all the messaging and marketing that goes along with that. How do you position that brand in the market? Are you a cutting-edge technology brand? Are you more of an old school old school brand that targets more of old school values and ways? How do you position that trademark within the industry? And that really then becomes your branding and your brand messaging. The other question that I get a lot, and it is a confusing one, your trademark is not necessarily the same as your company name, and it is not necessarily the same as your trade name, the DBA under which you're operating. You can have those three things be the same. Think Coca-Cola Company. The name of the company is the Coca-Cola Company. Their brand is Coca-Cola, and they do business as Coca-Cola. An alternative to that is a company like Kimberly-Clark. Kimberly-Clark is actually the company name. That's the legal entity. Kleenex is their brand. So it's the difference, and if you hearken back to 8th grade grammar, the difference between a noun and an adjective. When you're talking about the entity, the legal entity, that's when you're talking about your company name, your trade name. When you start talking about the brands and your products, that's when you start talking about your trademark. You will also hear the term trademark and service mark tossed about. A service mark really is the same thing as a trademark. It's just technically service marks are for services and trademarks are for products and goods. But most folks will just use the term trademark across the board. Another question I get often is, I need to trademark something. You actually don't have to do anything to get a trademark other than use that word, logo, tagline, what have you, in the context of selling products and services. Once you use a word, logo, what have you, in connection with the sale of a product or service, trademark rights will immediately attach to that. Remember, under U.S. law, the purpose of trademark law is consumer protection. If we had a set of laws that did not protect consumers without the company actually taking some affirmative action, then that would seem to be a cross purpose with the goal. Now, the trademark rights that you're going to get in that instance are going to be limited. They're going to be limited to the specific geographic area in which you're doing business. And I'll get to that more here in a minute. Something else to keep in mind when you think about trademarks, not all trademarks are equal. Generally speaking, the trademarks or the potential trademarks that marketing people love are the ones that I typically kill, because from a marketing perspective, you want a trademark that immediately conveys to your potential buyers who you are, what you do, what your product or service is. Makes it much easier to market when you don't have to develop all of that. However, those are typically the ones that are more difficult to protect. If you think about it like a spectrum, if you take the term Apple and you apply that to a computer, there is absolutely no connection, theoretically, between an Apple and a computer other than the brand value that Apple has created in that. If you take the term Apple and you apply it to an apple farm, there you have an immediate, what you're selling is the thing that you're trying to market it under. In that instance, if you were to allow the apple farmer to get a trademark on Apple for selling his apples, you would necessarily prevent all other apple farmers out there from making an honest living because they would no longer be able to fairly describe their product. So when you think about what you want as a trademark, think about it along these lines. The more you go down that bullet point list, the easier it is to protect from a trademark perspective, the more value you're going to be able to build in it. It's going to take longer and it could be more expensive, but you're going to be able to gain some of that protection. So I mentioned earlier, how do you get a trademark? And the fact that if you don't have any kind of registration, your trademark rights are going to be limited to the geographic area in which you use it. So if you're using a trademark out here in Arizona, you're going to have some limited trademark rights in Arizona. If you're using your trademark in Arizona, Nevada, and California, you're going to have some trademark rights out in that part of the country. That would not necessarily prevent somebody from Maine in launching a similar product using a similar mark, because you have no protectable trademark rights there, which is why oftentimes folks will look at the federal registration process. What the federal registration process does is takes those local rights that you have and blows them up on a nationwide scale. So once you start operating within Arizona, California, Nevada, you then take, you can then take those local trademark rights so that you could prevent somebody in Maine from offering a similar product using a similar brand. And then I've got a note here in terms of it is a matter of federal law that prevents somebody, and most states have statutes as well, oftentimes with a bit different standards, but would allow you to prevent somebody else from offering a similar product using a similar brand, allowing you to carve your place out in the market. So is this then the best? We've gone through all of them now. Which one do I need? As we mentioned, what trademarks do in terms of preventing somebody else in the same line from doing something that could be confusingly similar to consumers, but it's not going to prevent competition, and it's not going to prevent anyone from reverse engineering. So at the end of the day, as you've looked at each of these 4 types, hopefully the message that you've gotten and can take away from today is that none of these by themselves are the end-all be-all. There's not one silver bullet where you can look to for any particular product and service and say, that's the one I need. And they're not intended to be. Each of these serve different purposes, have different rights, different remedies, and it's a strategy of each of these working together oftentimes that allows you to create your product within the market, to exploit your product within the market and create that niche from your idea to your particular expression of it to the branding and marketing of it. Each of these is going to have a different purpose and hopefully a bit of a way to help you give some calm to your business folks in terms of actually protecting the newest Uber spinning gizmo. So with that, I think we have like 2 minutes for questions. So certainly if there are any questions, let us know. We can rotate through the offices. I'm not seeing any questions online. I'm assuming there was nothing here in Phoenix. Chicago. Milwaukee. Tampa?
No questions.
Perfect, thanks. Naples? DC? Indy? Who'd I miss? Madison?
Heather.
Tucson?
Oh, Heather, this is Martha in Madison. Could you just speak really quickly to the advisability of registering a copyright for source code versus the typical trying to just keep that as a trade secret as much as possible?
Yeah, absolutely. And obviously, since the purpose of patent and copyright are both to allow works to be disseminated, it is the case that with copyrights, when you want to file a copyright registration, you have to file a copy of the work. And so if there is something, and it typically comes up in source code, that you consider to be a trade secret within that source code, then one of the things to keep in mind is, do I really want to file a copy of this with the Copyright Office where it's going to be, a copy of it's going to be live forever in the Library of Congress? It is possible under the registration process, particularly with source code, that if you have portions of your source code that you consider to be trade secret, you can block them out. What the Copyright Office requires is 50 pages of source code. It used to be the first 25 pages and the last 25 pages of source code, and there were a couple of other alternatives. With software development these days, if you ask a developer to give you the first 25 pages of code and the last 25 pages of code, they're going to laugh at you and say there is no such thing. So the Copyright Office has changed their standards, and really they just say use your best efforts to figure out what are the first 25 and the last 25. But you can block out of those components those portions that you consider to be trade secret, so long as you're not blocking out everything. There is a bit of a percentage standard that you need to keep in mind when you do that. So it is possible to still file for source code as a work of authorship and still keep those trade secrets protected. But again, depending on the nature of the software, something to give thought to.
I have a follow-on question to that. Is patent law like that? I always understood that the trade-off in a patent is you teach the world how to do it, and in exchange for that, you get exclusivity for a limited time. Can you have a trade secret that you patent?
No, you're exactly right. That is precisely the trade-off. And I think that's why we said in the presentation that, you know, if you are looking at things that may potentially be protected as a trade secret, but you have some concerns that they may leak out and become public via one mechanism or another, that's when you think, well, do we want to pivot, start looking at patent protection, but the trade-off being that this patent is a document that will teach people about our technology. That teaching is done in exchange for the exclusivity rights that we talked about. So no, there's no kind of redaction option available for a patent.
Does the work made for hire concept apply to patents and trademarks as well as copyright?
I'll let Rowan speak to the patent piece of that. From the trademark perspective, it does not. The only way that those two concepts would cross in a trademark context is if you are developing a logo as your brand, or I suppose if you had somebody like a advertising firm come up with a particular trademark for you. You know, you hire them and they give you 3, 4, 5 options, and you get to pick which one you want. From that perspective, the work and the deliverables that the advertising company create for you could be works made for hire, or if your employees are developing them in-house, again, could be works made for hire. But again, the rights that we'd be talking about in that context would still be copyrights. You're not going to have any trademark rights until you actually put that trademark on a product or service and sell it out the door. And those rights will always inure to the benefit of the company, individual, what have you, that is doing that distribution and selling.
I think it's a similar answer on the patent side. So if we look at software as an example, if we've got someone developing code for us, it's perfectly conceivable that both copyrights and patents could be IP rights associated with that software development. There could be copyrights on the source code itself, in which case the work for hire concept would attach on the copyright portion of that. The patent piece, though, would be entirely separate. We wouldn't really, the patent would be on the technological innovation that's embodied in the software. We would get ownership of that, the invention there, by some form of written agreement, and the work made for hire concept would not attach on the patent side.
So what you could end up with in that position is if you didn't have a contract in place with your employee, you could end up in a position where the company owns the copyrights because it was an employee acting in the course of their employment, but you would not own the underlying technological innovation that is embodied within that source code. Again, the separation between the idea and that particular expression of that idea.
Yeah, and just to be clear, in that situation, you may have some limited rights, but clear-cut ownership would not be the case. You'd have to have a written agreement to effectuate that.
Anything else? Otherwise, I think we are about 4 minutes over. So with that, unless there's anything else, I think we'll wrap it up for today. Again, thank you all for coming. Kathleen gave us the announcement for next month's BLT, and we look forward to seeing everybody there.